In 1966, the year in which Major Mike Webb was born, and 2 years after the passage of the Republican-initiated Civil Rights Act of 1964, which was strenuously opposed by even Southern Dixiecrats of the Old Dominion state, Virginia, who celebrated during the last midterm elections and who denied victory to the current administration, the only state below the Mason-Dixon line to do so, in the still contested election of 2016, opposed passage of that enactment. In writing for the majority, Justice Stewart, framing the issue before the nation's highest court, wrote in relevant part, "This case presents questions concerning the scope of a century-old federal law that permits a defendant in state court proceedings to transfer his case to a federal trial court under certain conditions, specifically the provision permitting a state criminal action to be removed to the federal district court on a properly and timely filed petition." On January 15, 2019, shortly before the annual observance of the birthday of Reverend Martin Luther King Jr., in the quiet chambers of the federal district court in the city of Alexandria, Virginia, with a stroke of a pen, a federal judge erased the history of that famous case known as Georgia v. Rachel, and both the civil rights organizations like the NAACP and the black churches and progressive activists refusing to challenge abortion or oppose their new masters in the Democrat Party, who have bought their allegiance with funding and social programs, refused to oppose this court decision. Justice Stewart, in Georgia v. Rachel, went on to explain the facts of that 1966 case thusly. The case arises from a removal petition filed by Thomas Rachel and 19 other defendants seeking to transfer to the United States District for the Northern District of Georgia criminal trespass prosecutions pending against them in the Superior Court of Fulton County, Georgia. The petition stated that the defendants had been arrested on various dates in the spring of 1963 when they sought to obtain service at privately owned restaurants open to the general public in Atlanta, Georgia. The defendants alleged their arrests were effected for the sole purpose of aiding, abetting, and perpetuating customs and usages which have deep historical and psychological roots in the mores and attitudes which exist within the city of Atlanta, with respect to serving and seating members of the Negro race in such places of public accommodation and convenience upon a racially discriminatory basis, and upon terms and conditions not imposed upon members of the so-called white or Caucasian race. Members of the so-called white or Caucasian race are similarly treated and discriminated against when accompanied by members of the Negro race. More specifically, Justice Stewart explained, each defendant, according to the petition, was then indicted under the Georgia statute, making it a misdemeanor to refuse to leave the premises of another when requested to do so by the owner or the person in charge. On these allegations, the defendants maintained that removal was authorized under both subsections of 28 U.S.C. Section 1443. The defendants maintained broadly that they were entitled to removal under the First Amendment and the Due Process Clause of the 14th Amendment. The passage of the Civil Rights Act and this specific provision was so inspiring that one African American in the county of Arlington was inspired to pursue a career in the law and went on to become the chief judge of the Arlington County Circuit Court. And immediately after he learned of its passage, it is said that he went out to a restaurant to purchase a hamburger. But perhaps after marrying the divorcee of the Black Entertainment Network mogul, affluence changed something within him, bringing his silence when his counterpart, the African-American Chief Judge of the Circuit Court for the City of Alexandria, decided to ignore the precedent in Georgia v. Rachel by acting to nullify that civil rights provision, handing down a conviction, while a petition for removal to federal district court was still pending, despite the specific provisions in that act that prohibited a conviction until it was remanded from the federal district court. Perhaps forgetting their history, both African American judges, having finally gotten their piece of the pie, not only continued to oppose the challenge on appeal to the Fourth Circuit of Appeals in Richmond, but also one took further actions to prevent that African American litigant from filing any other future allegedly frivolous and vexatious lawsuits, permanently barring him from filing any future papers with the Arlington County Courts without an attorney licensed by the state, in clear violation of his Sixth Amendment right to represent himself, as recently reiterated in the United States v. Cohen in 2018, a Fourth Circuit case. Yet on November 6, 2018, immediately after the election in which Senator Tim Kaine rejoiced about a statewide victory in flipping Virginia blue, the state in which he had declared after the election of Barack Obama that old Virginia was dead, the Fourth Circuit affirmed the denial of a petition for removal on grounds that no such procedure addressed in Georgia v. Rachel had ever existed. And then, upon reconsideration, without acknowledging any error, affirmed the denial of the petition for removal, like in the Rachel case, that the criminal defendant had presented his petition timely, had failed to present facts in an extensive affidavit that had alleged any discrimination. Moreover, the Fourth Circuit affirmed the contention that the case was filed as a civil case, whose case number was altered to place it on a criminal track sua sponte by the court, was improperly filed as a criminal case and not as a civil matter. On petition for rehearing, not even with the aid of the NAACP, which endorses abortion, apparently even in Ohio, even to the point of infanticide after birth for black babies, the petitioner charged with the crime of trespass wrote, even accepting the decision of the district court in the most favorable light, Patterson v. Calm, a Virginia State Supreme Court case decided in 1924, the year in which Major Mike Webb's grandfather, a preacher, was shot in a small North Carolina town just south of Danville because he looked a lot like he was going to vote. A case decided under the predecessor Civil Rights Act of 1866, in which the petitioner had sought removal to the wrong court, that Dixiecrat Jim Crow era court, which began by noting the spectacle of ignorant Negroes that the lower court must have observed, and which went on to affirm a conviction for murder, deeming the determination of a motive unessential in the interest of justice still held, it would be extremely technical to refuse a removal to district court on this ground. We shall treat the application as one for removal to the district court, and that court did that in the interest of justice. The petitioner, on reconsideration, continued. The opening paragraph from that case stated, "The plaintiff, in error, is a Negro. He was indicted for killing a man whom the Negro witnesses describe as the Jew, was tried, convicted of murder of the first degree, and sentenced to be electrocuted. Most of the witnesses for and against him were also Negroes, and a very ignorant set. Some of them were unable to tell their ages or the time by the clock, and one of them could not tell whether 5 minutes or 10 minutes were the longer time. Many of their statements seemed highly improbable, and they had very inadequate ideas of time or distance, and yet they did not hesitate to give their opinions on the time of day or night when events occurred, or the distance of one place from another. It was chiefly with reference to such matters that their statements were confused or contradictory. When confronted with inconsistent statements in their testimony and asked which was correct, several of them answered both, and one of those who gave such an answer was a preacher who was supposed at least, to be better educated than the rank and file of his race. The jury who saw their demeanor on the stand and heard them testify were far better qualified to ascertain the facts than this court can be from simply reading the printed record. There was enacted before them a scene that could not be transmitted to this court. And the petitioner, on a petition for reconsideration of the repeal of the civil rights provision that the NAACP would not defend against, stated in conclusion, accordingly, failure to reverse on a mere technicality under any pretext rationale, especially in light of the apparent error by the district court in losing a properly filed civil action and assignment of a matter as a criminal action that deprived the petitioner of notice of the matter he had filed, would be anachronistically prejudicial and far worse than the disposition of the court in Patterson during the age of Jim Crow. And this dismissal, therefore, in the interest of justice, must be removed. This case now, again before the Fourth Circuit, makes clear to any thinking person that when Planned Parenthood founder Margaret Sanger wrote to Dr. C.J. Gamble on December 13, 1939, "We do not want the word to get out that we want to exterminate the Negro population, and the minister is the man who can straighten out that idea if it ever occurs to any of their more rebellious members," she was not just concerned about having her words taken out of context. And this may well be why her portrait was recently removed from the Planned Parenthood Museum to erase that history. This case now before the Fourth Circuit makes clear why the NAACP during the 2016 elections chose to adopt a resolution to declare a moratorium on public charter schools, the only solution that has to date begun to address the achievement gap, a problem that Arlington, Virginia has faced for over 150 years in a troubling history that denied access to public education that even General Lee provided to the slaves on his plantation. A municipality that forced its black residents to seek an education across the Potomac River in the nation's capital and refused to pay for it. A municipality in which former Democrat Governor Byrd recalled the entire school board to resist the mandate of the Supreme Court in the landmark decision of Brown v. Board of Education, and that had denied 26 applications of African American applicants to Washington Lee High School in 1959, the same year in which it was compelled by the federal court to end its opposition to the Supreme Court and desegregate, a school district in which the only African Americans recognized for outstanding achievement in the year that they decided to change an allegedly offensive name on a high school were not for any academic achievement, but for athletics, and a school district still fighting an appeal at the state Supreme Court to defend its decision to discriminate against African Americans in the Washington Lee High School Renaming Committee Policy Implementation Plan, providing preference to the Arlington Civic Federation, the White Citizens Council that more likely than not chose the offensive name in 1921. Major Mike Webb, an unabashed deplorable and supporter of the current president, is not just in these fights on Facebook, but also in the courts, at his own expense, and in 2020, African Americans cannot afford to wake up surprised. And so in November, it is a referendum election where you have the power to choose between the party of manumission, slavery, oppression, Jim Crow, and subjugation, or to choose the party of emancipation. In November, you have the power to choose between the party of welfare entitlement and government dependency, or the party of opportunity. In November, you have the power to choose between the party of underperforming public schools and achievement gaps, or the party of school choice. You have the power to choose between the party of mandatory union membership or the party of a right to work. You have the power to choose between the party of universal socialized medicine or the party that will let you choose your provider and your doctor and your insurance plan. In November, you have the power to choose between the party of awaiting the arrival of law enforcement or the party of the right to stand your ground and defend yourself. In November, you have the power to choose between the party of higher taxes and growing bureaucracies or the power of lower taxes and self-determination. It is your party and it is your choice. I am a Christian, a conservative, and a Republican, in that order. And I am not ashamed of the gospel. My name is Major Mike Webb, and I am running for U.S. Congress, not unmindful of the future, with liberty and excellence. Let's make America great again. Honest. This advertisement was authorized by Mike Webb.